Waqf registration was required since 1923. With this powerful remark, the Chief Justice of India, B.R. Gavai, set the tone for one of the most heated courtroom debates in recent memory. On May 22, 2025, the Supreme Court of India reserved its order on a batch of petitions seeking a stay on the Waqf Amendment Act 2025. Over 3 intense days of arguments, the apex court was drawn into a storm of constitutional questions, community concerns, and religious identity debates. At the heart of the controversy lies a series of amendments passed by the government altering how Waqf properties are identified, managed, and even created in India. But is the new law a genuine reform or a backdoor attempt to dismantle age-old religious endowments? The bench was headed by CJI B.R. Gavai, sitting with Justice Masih. Together, they heard extensive submissions, first from the petitioners on May 20th, then the Union government on May 21st, and finally closing arguments on May 22nd. Solicitor General Mehta, appearing for the centre, argued that Section 3E, which bans Waqfs on tribal lands, is meant to protect scheduled tribes from irreversible dedication of land. But Justice Masih sharply responded, Islam is Islam. Religion doesn't change just because a person is tribal. The Solicitor General insisted that Waqf registration has always existed, first under 1954 and informally even under 1923. Non-Muslims were not allowed to create Waqfs in older laws. The 2013 amendment was an exception. Now, reversed. Even if a non-Muslim wants to contribute, they can donate to a Waqf or create a trust. On the controversial 5-year practice clause, he said it's similar to declarations under the Shariat Act and not meant to alienate rightful claimants. And crucially, he argued that the new provisions aren't blatantly unconstitutional, so no stay should be granted at the interim stage. But the petitioners, led by senior advocate Kapil Sibal, tore through the government's defense. He pointed out that while registration may have been required earlier, states failed to enforce it. So why, Sibal asked, should millions in the community be punished for the government's own lapse? He also raised concerns that Section 3D, allowing the government to derecognize Waqfs on mere suspicion of encroachment, was never even approved by the JPC. Dr. A.M. Singhvi called the new registration rules a vicious circle. Waqfs by user are abolished. Yet you can't register anything unless it's proven not to be government land. How can a non-existent category be registered? Another explosive claim came from the government that Waqf is not an essential part of Islam, but senior advocate Rajeev Dhavan hit back. He cited Quranic verses, JPC reports, and the Union's own past statements, asserting that charity and Waqf are central to the Islamic faith. In a stunning moment, an intervenor from Tamil Nadu stood up. She represented a village where an entire settlement, including a Chola-era temple, had been declared Waqf land. Earlier, in April, the court had proposed no Waqf property already declared by courts be derecognized. Only Muslims should be appointed to Waqf boards, barring ex officio members. The centre agreed not to make any appointments or alter Waqf status until further notice. This isn't just a legal battle, it's also a political war zone. Petitioners include AMIM's Asaduddin Owaisi, AAP's Amanatullah Khan, TMC's Mahua Moitra, Indian Union Muslim League, Jamiat Ulema-e-Hind, DMK, and many more. On the other side, BJP-ruled states like Assam, Rajasthan, Chhattisgarh, Uttarakhand, and Maharashtra have backed the new law. The main provisions being challenged include the abolition of Waqf by user, exclusion of non-Muslims from creating Waqfs, 5-year religious practice clause, invalidation of Waqfs over ASI monuments, and the empowerment of revenue officers to change records without judicial process. As arguments ended, CJI Gavai reminded everyone from 1923 till 2025, over 100 years, the law has always recognized the need for registration. But Sibal countered, then why were Waqfs never registered? Because states failed in their duty. Now, the community bears the burden of that failure. The court has reserved its interim order, and what comes next may redefine how India handles religious endowments, especially in a time when faith, law, and politics are so deeply entangled. If you found this report insightful, don't forget to subscribe to the channel and share your thoughts in the comments below. For detailed legal analysis and real-time updates, stay connected with Kanoonplus.